Good evening to everyone. My name is Rohan Kumar, and I welcome you all in the final round of First Lex Explorer National Moot Court Competition, organized by the Lex Explorer Legal Journal. For the very first, I would like to introduce our honorable judges of this round. Honorable judges of this round are Ms. Paridhi Saxena, Editor Director of Lex Explorer, as well as founder and managing partner at Tarkic Legal. Mr. Avinav Gupta, Editor in Chief at Lex Explorer, and Dr. T. Balaji, Assistant Professor at Dr. B.R. Ambedkar Government Law College. We are delighted to have you all here. Now I would like to welcome our both the teams who have qualified for the final round. We are delighted to have such a wonderful mooters here. Today we have us team code 46 from the side of petitioner and the team code 52 from the side of respondent. Each team shall be allotted a total time of 50 minutes, out of which each speaker can take maximum of 25 minutes only, and 5 minutes may be allotted for rebuttal and surrebuttal. A time extension of the maximum of 5 minutes may be granted to each team at the discretion of the judges. The speaker of both the teams will be notified in the chat box when the 2 minutes are left for each speaker to indicate the time. Since both the teams and judges have joined with us, now I declare the court is in session and let the speaker one of the petitioner side plead, followed by speaker two.
Good evening. The Council seeks permission to collectively address the bench as Your Honor.
Permitted.
Much obliged, Your Honor. The Council will be representing the petitioner. I am the first counsel and I will be dealing with the first and the second issue, and my co-counsel will be dealing with the third issue along with the prayer. The Council seeks permission to proceed with the facts of the case.
Keep it brief.
Much obliged, Your Honor. Mr. Chotelal married to Kiran Kumari on 1st of January 2020. Kiran Kumari had lived an exquisite lifestyle and she wanted to continue to live it. So she was demanding from Chotelal for a luxury car. However, Chotelal was not financially capable enough to fulfill such lavish demands. He requested his father-in-law, that is the father of Kiran Kumari, to fulfill her demand for now. Later, Kiran Kumari and Chotilal together wanted to purchase a piece of land and they were in short of money. Thus, he sought his father's help for completing the payment and agreed to pay it back later. Also, during this time, they had certain quarrels as that in a normal marriage. And also, since she had not been to her parents' home for a long time, he suggested her to spend some time at her parents' home. After a few days, Chotilal Kumar had a change of heart and he brought his wife back to his home. He apologized to her and promised to keep her happy. On 10th of September 2022, Kiran Kumari went to her father as Chotilal was in urgent need of money and asked for 60 lakhs. On 15th of October 2022 at 9 a.m., Kiran Kumari died of strangulation due to suicide at her matrimonial home. Her father lodged an FIR to the police. The police registered the FIR, held the inquest over the body, and sent the same for post-mortem. After completion of the investigation, the charge sheet was filed under Section 304B of the Indiva Penal Code against Chotelal Kumar. During the investigation, police recovered a diary written by Kiran Kumari. The accused took the plea of alibi and adduced the evidence to show that he was in office at the time of offense. The learned court considered the diary as a dying declaration and ignored the plea of alibi without examination. The trial court convicted our client under Section 304B and 498A of Indiva Penal Code and awarded him a sentence of imprisonment for life, punishable under Section 304B of IPC. On appeal, the Honorable High Court agreed with the conclusions reached by the trial court and dismissed the appeal. The petition approaches the Honorable Supreme Court to seek a special leave petition under Article 136 of the Constitution of India. If Your Honor is well versed with the facts of the case, the Council seeks permission to continue with the arguments.
Yes.
The Council seeks permission to address the first issue of the argument. Much obliged, Your
Permitted.
Honor. The special leave petition brought by the petitioner before this Honorable Supreme Court is maintainable because it is a question of law of general importance. It is a substantial question of law, and the judgment of the previous courts is erroneous, and justice is not done. The jurisdiction conferred upon this Honorable Supreme Court under Article 136 is a corrective one and not a restrictive one. It is well settled that there is a duty enjoined upon the Supreme Court to exercise its power by setting right the illegality in judgments, and failure by the Supreme Court to interfere with the same would amount illegality to be perpetuated. This honorable court has also held in previous judgments that when a question of law of general importance arises, or the decision by the previous courts shocks the conscience of the court, its jurisdiction can be invoked. In the current case, the fact that our client was not given a fair trial, and the plea of alibi that was contested by him was not examined at all, and the evidence adduced along with it was completely rejected without examination, shows that he was not given a fair trial. In the current case, if there is a miscarriage of justice and a wrong decision is given, it would create a sense of fear among the society, and would also hamper the law and order in the society. The expression substantial question of law is not defined in any legislation. However, it has been given definite connotations through various judicial pronouncements. In the case of Chunilal v. Mehta and Sons Limited versus Century SPG and Manufactured Co. Limited, the constitutional bench of this Honorable High Court explained the expression of substantial question of law, and observed that the proper test for determining whether a question of law raised is substantial one would be when the question is of general importance, or whether it is directly or substantially affecting the right of the parties. In the present
Counsel,
case, yes, Your Honor.
in Constitution 136, Article 136, where it is mentioned that general principles and all.
Sorry, Your Honor. Could you please elaborate your question?
So in 136, do you have a constitution?
I would seek a moment, Your Honor.
Yes. You have?
Yes, Your Honor.
Yes. Just read that.
According to Article 136, notwithstanding anything in this chapter, the Supreme Court may in its discretion grant special leave to appeal from any judgment, decree, determination, sentence, or order in any cause or matter passed or made by any court or tribunal in the territory of India. Nothing in Clause 1 shall apply to any judgment, determination, or order passed or made by any court or tribunal constituted by or under any law relating to the armed forces.
So in this article where it has been mentioned that substantial question of law can be come before this court under Article 136.
Your Honor, in the case of Chunilal Mehta versus Sons and Sons Limited versus Century SPG and Manufactured Co., it was said that when there is a substantial question of law that is involved, then in the case it can be contested to be it can be contested to be maintainable under Article 136 of the Constitution.
Then what is 134, 135?
It is regarding the appellate jurisdiction of the Honorable Supreme Court.
For criminal cases, no 134.
Yes, Your Honor.
Why you choose 136 rather 124, 134? You
Uh,
can come here by 134 itself, no?
Since Your Honor, the appeal under 134 was not granted by the High Court, the petitioners have brought before the Honorable Supreme Court under Article 136.
Okay, proceed.
As it was proved as the point that the substantial question of law involves to be a question of law that of general importance and substantially affects the right of the parties. In the current case, the question of law involved is of recurring nature that has been raised in a plethora of cases. This shows that it is very important to decide the judgment for this question of law to be done properly. All facts are examined, and it is according to the principles of natural justice and law. Therefore, this shows that this is an important and substantial question, and also the fact that if there is a miscarriage of justice and an erroneous judgment is given, the fundamental rights of the our client will be largely affected. And also the fact that he was given a serious punishment as that of an imprisonment of life without properly examining the facts, and also looking into the plea of alibi. Therefore it is to be contested that it is a question of law. Also under Article 136, the power is a residuary power, and if the court is satisfied that there is injustice, then in the case the court can intervene. In the case of Sirpur Paper Mills versus CVT, it was held when the Supreme Court reaches the conclusion that a person has been dealt arbitrarily, or the court or tribunal has not given a fair deal to a litigant, then the court can exercise this its power under Article 136. Also, in the case of Jamshed Hormushi Wadia versus Board of Trustees, Port of Mumbai, uh, the court had held that the Honorable Supreme Court can intervene when the previous courts failed to give substantial justice or perpetuated grave injustice to the parties, or have given a judgment that shocks the conscience of the court, and there is a disregard to the legal process, and the judgments are in violation of the principles of natural justice. In the current case, the plea of the appellant that he was at the office was not considered properly, and his evidence given for the same was rejected and not examined at all. And this very plea of accused was very important to prove his innocence. Thus, we contest that he was not given a fair trial, and the judgment given by the court was,
Counsel,
yes, Your Honor.
the fact that you're claiming that the appellant was at his office, so is it a matter of fact or matter of law?
It is a matter of fact
Does Supreme Court
that
look
is
into
crucial.
matter of fact?
In the current case, it is a matter of
Do we
fact.
rev would we review the matter of fact, or we will review the matter of law?
It would review the matter of law. However, the matter of fact in the current case becomes crucial to uh, in the case of law, because in the current case, the entire the conviction of the of our client in the current case is on the basis of this fact. Therefore, it also becomes an important question.
Please proceed.
Yes, Your Honor. Therefore, there was miscarriage of justice in this current case, and the judgments of the previous courts were erroneous. Therefore, the special petition brought before this honorable court is maintainable. The council seeks permission to proceed with the second issue.
Permitted.
During the investigation of Kiran Kumari's suicide investigation, the police recovered a diary written by Kiran. The trial court had unjustly considered the diary to be a piece of dying declaration, and the High Court concurred with the view. The statement, according to be considered to be a direct dying declaration, means only such facts or series of facts which have direct or organic relation to the death. In the case of Kapil Rajvanshi versus State of Bihar, where the death of the wife was caused due to burn injuries, the statements made by the deceased wife to her parents orally and in her letter complaining cruelty subjected by her husband before the occurrence had considered to be not amounting to dying declaration under section 32 of the act, as they do not relate to the cause of death of the deceased. The SC has also held that the evidence of the prosecution witness about torture or harassment meted out by her, by the accused, has no connection with the circumstances of transaction which resulted in her death, and therefore would not be admissible as dying declaration of the deceased. Also, it is necessary to be established that there must be a proximate and live link between the effect of cruelty based on dowry demand and the death concerned. If the elect incident of cruelty is remote in time and has become stale, and it was not enough to disturb the mental equilibrium of the woman concerned, it would be of no consequence. Also, no presumption under Section 113 of the Evidence Act can be drawn against the accused if it is shown that the elect demand cruelty or harassment in the dispute stands resolved and there was no evidence of cruelty or harassment. In the present case, there were only demands for money that were made, and there was no demand for dowry, and also a long period had passed since the past demands, and therefore it cannot be considered. Also, it was for the benefit of both of them, so we cannot say that it had affected the mental equilibrium of the disease in the current case. Also, the death of the disease in the current case is not in relation to the demands that were made, and therefore it is contested that a dying declaration cannot be considered. There was no direct nexus or reasonable nexus between the circumstances and the death of the disease. Also, the dying declaration, also the conviction based on only on dying declaration is not proper. If the dying declaration is not corroborated by other evidence, then the accused is entitled to be acquitted. In the case of Ramnath Prasad versus State of Madhya Pradesh, the Honorable Supreme Court had held that it is a settled law that it is not safe to convict an accused merely on the basis of evidence of dying declaration, because it is a statement that is not made under an oath, and it is not subjected to cross examination, and it is not the mental and the physical state of mind uh, of the disease is not checked. Also, it can be the dying declaration of also the statements that were made to be considered as a dying declaration can be a product of imagination of the person, and in the current case the diary is a mere representation of her emotions and of feelings of a particular circumstance. We cannot conclude that they are the direct representation of the facts in the situation. She may, in a burst of anger or a burst of emotions, have written down the feelings, and therefore it must not be considered that the current diary is a dying declaration. Also, the fact that it was not recorded by judicial magistrate would also reduce its evidentiary value. Thus, in the current case, it is humbly submitted that the inclusion of a statement as in the diary as the only way of as a dying declaration would defeat the ends of justice, as the conviction is solely on the basis of the dying declaration considered of the diary that is considered as a dying declaration. Now my co-counsel will be dealing with the third issue.
At this juncture, the Council would like to point out all the submissions made by this Council are without prejudice to those made by my co-counsel, and along with the Council will be presenting one distinct issue. The Council pleads that the judgment given by the trial in the High Court is erroneous. The courts are not right in holding the accused liable under Section 498A and 304B of IPC, and substantial justice has not been done. Principles of natural justice have been violated, and the plea of alibi needs to be considered. The petitioner is not guilty under Section 498A of IPC. The prosecution, with malified intention, has filed a case on Chotilal under Section 498A and 304B of IPC. In Rajesh Sharma vs. State of UP, the court issued directions to prevent the misuse of Section 498A. The court stated that it is a matter of serious concern that large number of cases continue to be filed under Section 498A, alleging harassment of married women. This court had earlier noticed the fact that most of these complaints are filed rather in the heat of the moment and over really trivial issues. Many of these such complaints are not bona fide in nature. In the present case as well, the father of the deceased was in grief after finding his daughter in that state and has wrongfully registered the FIR in the above mentioned sections of IPC. At the time of filing the complaint, implications and consequences were not visualized by the father, and such complaints had led to uncalled for harassment of the accused. According to State of AP versus M. Madhusudan Rao, every harassment does not amount to cruelty within the meaning of Section 498A. For the purpose of this section, harassment simpliciter is not cruelty, and it is only when harassment is committed for the purpose of coercing a woman to meet an unlawful demand for property or valuable security that it would amount to cruelty punishable under Section 498A. Chotelal here did not make any unlawful demand to fulfill basic necessities such as buying a plot and a car, which was for both himself as well as the deceased Kiran Kumari, and to make sure the accused make sure that the deceased led a comfortable lifestyle, as she came from a very prominent, well-off family, and thus it would not amount to cruelty. As the provisions of this act are clear in that whenever the demand for dowry is also made, there needs to be information to the dowry prohibition officer within the stipulated demand. However, in the instant case, the demand made was agreed upon and accordingly submitted by the father of Kiran Kumari. It is to be noted that it was not a demand for dowry, rather an agreement of money between Chotelal and Kiran Kumari.
Council, I
In
have a
A.
question.
Jayachandra versus Anil Kaur,
Yeah. When you say the term basic necessities, can you define what you mean by basic necessities?
basic necessities, yes, Your Honor, here in this case, basic necessities relating to the facts of the case would be a house to live in, a car, and to fulfill their basic demands,
So
day to
when
day.
you say a house to live in, so does that mean buying a plot? And like that implies that did not have a house to live in already. So, like, are you getting my question? If they had, like, if you're saying buying a plot is one of the basic necessities, then it would imply that they do not have a house to live in, right? How would you
Yes,
determine this thing? How would you determine buying a plot or for that matter a car as a basic necessity?
Your Honor, here Chotelal and Kiran Kumari, after their marriage, did not have a shelter of their own, a matrimonial home of their own, which they were seeking as any wife or a husband in a marriage would, is what we are saying.
So if
Council,
they,
would you differentiate between a luxurious life and basic necessities of life? Are we getting confused there? Because
Your
that's what
Honor,
my co-judge is trying to point out.
Your Honor, here Kiran Kumari has led a lavish lifestyle because she was from a prominent and a well-off family, and moving in with Chotelal, who might not be as well-off, uh, could have created disputes
So
in
how
their
can you
time of
presume
their
a
marriage.
character of a deceased?
Your
Is
Honor,
anywhere in the fact it said she want luxurious life and all, and then she spend lavishly. Anywhere in the fact sheet it's there. How can you
uh,
presume that? And then one more question: is their father agreed for the dowry?
Your Honor, the fact that he's given alleged dowry is saying that it's an agreement of money that was received.
There is no agreement.
Your Honor, the act of the father giving the money uh, to
Yes,
Chotelal
Chotilal
Kumar is
Kumar
the agreement.
continuously he demanded for her daughter, he gave. So there is no agreement there. So it's clearly stating that Chotla Kumar regularly demanding the money. For her daughter's sake, he is giving.
Your
So it's
Honor,
clearly shows that Chotla Kumar continuously asking.
Your Honor, here what we are saying that Chotelal Kumar did not actually ask for dowry. He seeked help from his father-in-law for the basic necessities, and the dowry demands were actually not very consistent in nature. And we are assuming that to meet the regular demands of the household, for them to lead a reasonable life is what the demands were made. And if father-in-law did not consider this as a dowry and not an agreement, he should have approached the proper authorities instead of giving the money. Since that did not happen, we believe that it was more mere an agreement of money.
But then when we say agreement, it has a little bit of legal binding. Okay, so keeping that thing apart for now, your co-counsel also just said that this demand was not a demand for dowry, but just a demand for some amount of money, and as you said, for some basic necessities. So again, my question still remains that how would you first of all determine whether any demand for any amount of money is for dowry or not? First of all. Secondly, again, how, like, when you say they did not have a house or to live in their matrimonial home, so in that case it would mean that, like, were they living on streets, or I mean, what was that? First of all, the reason why they wanted a plot and not, for that matter, a house, a already built in house. Secondly, when you say about purchasing of a car, so why only a car? If you talk about basic necessity, even a two-wheeler would have fulfilled that, at least for starters, is the accused here was not able to provide it. So what would you have to say about that?
Your Honor, we believe that the necessities here would be uh, considering the factors of how they led their life, both from the side of Chotelal and Kiran Kumari, right? So, what they deemed fit to be considered as necessity, or what works for them, would be considered as essential goods for the Kiran Kumari and Chotelal, and what they believed was right. They approached the father-in-law to receive in for the financial aid here, is what we're saying.
Do you have any judgment or any case law to support this claim?
Uh, Your Honor, may I take a moment of the court's time?
Or maybe you can just, continue your pleadings and we can come back to this at later stage.
Your Honor, in the case of Appa Saheb versus State of Maharashtra, a demand for money on account of some financial stringencies or meeting domestic expenses uh, cannot be termed as a demand for dowry, as the said word is normally understood. It was held.
I think that answers my question. Like, again, this will not, purchasing a plot or buying a car, again, would not amount to buying, domestic expenses.
Your Honor, we consider having a shelter and having a mode of transportation as essentials in a marriage, at least, for both of them to sustain.
Okay, proceed ahead.
And counsel, you are accepting that Chotlal Kumar asked all these demands, right?
Uh, yes, Your Honor. Both. We believe that it was collective, we asked.
So you believe that he demanded, and then Kiran Kumar's father gave, you received that money.
We believe that it was a collective demand. It was the demands were asked for the sake of both the parties, the deceased and the Chotelal.
Okay,
And the
proceed.
father has, in good conscience, thought that it was right to help them, give them this particular financial aid.
Okay, proceed with arguments.
In the case A. Jayachandra versus Anil Kaur, the Supreme Court observed that the foundation of a sound marriage is tolerance, adjustment, and respecting one another. Tolerance to each other's fault has to be inherent in every marriage. Petty fights should not be exaggerated or overblown to destroy what is supposed to be made in heaven. A too technical and a hypersensitive approach would be counterproductive to the institution of marriage. The courts do not have to deal with ideal husbands and ideal wives. It cannot be said that there should be a total harmony, and it is not uncommon and or unheard of for husband and wife to have quarrels. Such quarrels cannot be termed as cruelty to attract the provisions of Section 498A of IPC. In the current case, the appellant and the deceased had problems related to demands of money, but there was no drastic fights as such. The appellant further even apologized for his behavior, took her back to the matrimonial home, and promised to keep her happy. Thus, such minor disputes between them cannot be considered as cruelty. The courts were not justified in holding Chotilal under Section 498, liable under Section 498 of IPC, and the punishment given to him is not justified and not in accordance to the law. Section 304B of IPC is not applicable for the conviction of Chotilal. As stated before, in the case of Apa Sahib versus State of Maharashtra, a demand for money on account of financial stringency or meeting domestic expenses cannot be termed as a demand for dowry. In the current case, the demand for money was for purchasing a plot and a car. It was related to necessities and essential purposes. Thus, the demand would not fall under the purview of dowry. The essential ingredients of 304B of IPC were not met. In Amar Singh versus State of Rajasthan, the prosecution has established by convincing evidence that the accused had subjected the victim to torture soon before her death in connection with the demand for dowry. In each case, the court has to analyze the facts and circumstances leading to the death of the victim and decide if there is any proximate connection between the demand for the dowry and the act of cruelty or harassment. Looking at the facts of the case present, the council has established the acts of Chotilal does not fall under cruelty, and the demand for money being for necessities, followed by reparations that were advanced by Chotilal, should not draw any presumption under Section 113B of IEA, as there was no proximate connection between the demand for money and the alleged cruelty and Kiran Kumari's death. Section 304B necessitates that the woman should be subjected to cruelty or harassment by her husband in connection with any demand for dowry to constitute dowry death. In order to prove, it is to be established by the party complaining of cruelty that the conduct of the spouse has been of such character so as to cause danger to life, limb, or health, or so as to give reasonable apprehension of such danger. All types of cruelties cannot amount to dowry harassment. In the instant case, the accused made reparations and apologized and had promised to keep the deceased Mrs. Kiran Kumari happy. There was no evidence of cruelty and harassment for dowry on behalf of the appellant. Therefore, he would not be liable for conviction under Section 304B of IPC.
And
The
are you
natural
trying to say, counsel, are you trying to say that postmortem report that wounds and all self-made one?
Your Honor, we believe that the wounds that were received were received during the process of strangulation, during the process of suicide.
Do you have a Modi's jurisprudence, medical jurisprudence?
Sorry, Your Honor.
Medical jurisprudence by Modi, you have?
No, Your Honor.
No. So while hanging, the strangulation, all the wounds will happen. Bloody forth, everything will come. Are you sure about it?
Yes, Your Honor. Because of the strangulation is one moment. Yeah, the ligature marks that were found around the neck and the dissection of the ligature mark were present, and that's why ecchymosis was present. And so the trachea was also congested, and there was bloody froth, and there was all due to strangulations.
Okay, so you are telling that there is no cruelty.
No, Your Honor.
You aware the word mental cruelty?
Yes, Your Honor.
So Chotlal Kumar meant mental cruelty also. demanding the money from his father, her father.
But Your Honor, it is
Why
also
can't
to
we
be,
take that as a mental cruelty?
Your Honor, firstly, I would like to point out that the prosecution was alleging that this was a case of murder that was done by Chotelal. And secondly, we believe that there was no instances of mental cruelty. Firstly, because we believe that the demands were collective from both sides of the party. And secondly, there was no mental cruelty as there was no proximate link between during the time of the death and that of the alleged demands of dowry that have been made. The mental equilibrium of the deceased
Diary
was
that
not
was
to be disturbed.
counsel. What about the victim's diary that was found?
Yes, Your Honor, the victim's diary just states that uh, it was stating that how the narration, the dowry demands were made. They have not said anything. It was silent on the fact of cruelty and harassment.
So basically, don't you think that these demands for dowry are nothing but, with it leads to mental harassment or mental cruelty?
Again, Your Honor, I would like to say that there has to be a proximate link between that alleged cruelty that had happened and that the uh, uh, death of the deceased. And in this present case, we find no reasonable nexus between the alleged cruelty and the death. And also to be kept in mind that uh, Chotelal made reparations by promising to keep Kiran Kumari happy after bringing her back to the matrimonial home. And after such, no reported incidents of even demanding for money has been mentioned in the diary.
Okay, proceed.
Chotelal's principles of natural justices were also violated. The accused has been convicted under Section 498A and 304B of IPC. The proof of charge, which has to be beyond reasonable doubt, must also be depend upon the judicial evaluation of the totality of the evidences, whether they're oral, circumstantial, documentary, and not in an isolated scrutiny. The accused criminal charges were not proved beyond reasonable doubt as argued before this court, and there needs to be a proper judicial evaluation of the totality of the evidence, which the lower courts failed when they didn't get into the plea of the alibi of the accused. The CRPC ensures that the accused gets a fair trial. It is essential that the accused is given a reasonable opportunity to defend himself in a trial by the way of plea of alibi and to confront any such evidences that the prosecution is relying upon. Here, in this case, the dying declaration was considered to be the sole basis of conviction and and the charges of murder, which can easily be rebutted by the plea of the accused. It has been ruled in many cases before this court that it will not reassess the evidence at large, particularly when it has been accepted by the High Court. But the court interferes when it's shown that the principles of natural justice or deprivation of the rights of the accused were found when it comes to misreading of vital evidences or an improper reception or rejection of evidences, which would leave the conviction unsupportable. The In the present case, there has been a rejection of the plea of alibi of the accused, and it being a vital evidence and misreading of the diary of the deceased. The apex court need to interfere and delve into the plea of the accused. It is also to be noted that discretion under Section 233 CRPC must be utilized by trial courts as an obligation of best efforts. Once the court decides that the accused is not eligible to be acquitted as per the provisions of Section 232 CRPC, which happened in both the trial court and the High Court, it must move on to fix hearing specifically for the defense evidence, calling upon the accused to present his defense as per the provision provided under Section 233 of CRPC, which is also an invaluable right provided to the accused. Existence of such procedural right cohesively sits with the rebuttal presumption as provided under Section 113B of the Evidence Act. According to Section 233, the plea of accused should have been delved into as it is classified as the evidence of the defense. And after having this right of presenting his defense, the court should have he has the right to have a reasoned decision. One of the plainest requirements of a justice and a fair trial is that the trial court and the high court needs to notice, consider, and discuss, however briefly so possible, the evidence of witnesses as well as the arguments addressed at the bar, which was not performed by the trial and the high court, as they did not delve into the reasons rejecting the accused's plea of alibi and accepting the Kiran Kumari's diary as a dying declaration. Getting into the matter of why this plea of alibi is so crucial to the matter, the plea of alibi postulates the physical impossibility of the presence of the accused at the scene of the offense by the reason of him being at another place. The plea can therefore only succeed when it is shown that he was away and he could not have committed the crime. The accused in the present case was at his workplace when the alleged offense has been committed, and he had successfully adduced evidence for and since it's physical impossible to show that it was physically impossible for him to be at that place. The plea of alibi also did not fail on merit.
How can
It
you
was
say, counsel, how can you say it is impossible? Morning he went office, evening 5 o'clock he returned. Fact sheet says very clearly. And then fact says that all the investigation happened. But you are saying that there is no proper investigation and all. Okay, evening 5 o'clock he reached home. How can you
Your Honor,
say
it
it's
does not.
physically it is not impossible to come?
Your Honor,
In addition, counsel, when we are talking about offense of 304B under Indian Penal Code, does it require physical presence of the accused?
uh, no, Your Honor, it does not require the physical
Then your
presence of.
argument on alibi is completely thrown out of the window.
But we've also proved that there was no mental cruelty as such, and which it is also to be noted that Kiran Kumar, the alleged in the fact sheet itself, it's pointed out to us that uh, uh, the father of Kiran Kumari lodged an FIR to the police that his daughter was murdered by Chotelal because of dowry.
Right, but the charge sheet was filed for 304B, isn't it?
Yes, Your Honor.
Right? And he's being sentenced for 304B, not for murder.
Your Honor, but the case here being that it was it was also 304B. Your Honor, may I have a moment?
Please.
Your Honor, according to Section 304B, uh, the death needs to be caused by either the husband or the relative of the husband, which in this present case, either of them have not
Would you
committed the
mind
crime.
reading 304B for us?
Where the death of the woman is caused by any burns or bodily injury, otherwise than under normal circumstances, within 7 years of marriage, and it is shown that soon before her death, she was subjected to her husband or any relative of her husband in connection with the demand for dowry, such death shall be classified as dowry death.
Right. So it
And
says
such
soon before, right? It does not say right before, and it talks about cruelty and harassment. It does not talk about the physical presence of the accused or the members of his family, does it?
Your Honor, we have already made it clear that there was no mental cruelty as well, so as to disturb the deceased's mental equilibrium, that she would go ahead and commit suicide. There was also reparations made on behalf or by Chote Lal to Kiran Kumari, promising her to keep her happy. And after such reparations, there was no alleged demands for dowry. So we
Please
believe that
continue
it
with
was
your
not.
argument.
Yes, Your Honor. Where the plea of alibi was not did not also fail on the basis of merit. It should be pleaded at the earliest opportunity, and it should cover the time of the alleged offense. The credibility of an alibi is greatly strengthened if it is set up at the moment when the accusation was first made, and it is consistently maintained through the subsequent proceedings. The plea of the accused in the present case is that of a satisfactory one, as it was pled at the earliest opportunity, where it was during pre-trial after the charges have been framed. In regards to the second prerequisite, the accused should not be required to prove the exact time or every moment of time in order to sustain his defense. On the other hand, it is sufficient for him to raise a reasonable doubt at the presence of the scene of reasonable doubt of his presence at the scene of the crime at that it was committed. If there is a reasonable doubt in the mind of the court, the accused was not present, then then he would be entitled to acquittal. So the plea of alibi of the accused is the one of is satisfactory, as it is already contested by the counsel that the diary cannot be considered as a dying declaration. The court, considering the diary to be a dying declaration and the sole reason for conviction, is unjust and unlawful and
Speaker
erroneous.
2, sorry to interrupt you. Please seek extension of the time from the judges.
Uh, Your Honor, could you please repeat? I wasn't able to get that.
Sorry to interrupt you. Please seek the extension of time from the judges.
May I seek 2 minutes of the court's time?
Permitted, but keep it 2 minutes.
Uh,
Court
in
master, please look
conclusion,
into it.
In conclusion, the accused was wrongfully convicted under Section 498A and 304B of IPC, and the principles of natural justice have been violated upon not considering the plea of alibi of the accused and the conviction of the accused on the sole basis of the diary. Your Honor, may I move on to the prayer?
It's okay.
Therefore, in the light of the facts and circumstances, issues raised, arguments advanced, and authorities cited, it is humbly prayed that this Honorable Court may be pleased to adjust and declare the specially petition filed by the appellant under Article 136 of the Constitution to be maintainable. The diary written by Kiran Kumari cannot be considered as a piece of dying declaration, and the judgment of the learned trial court and Honorable High Court is erroneous. Also, to pass any other order which the court may deem fit in the interest of justice, equity, and good conscience. For this act of kindness, the petitioner shall be duty bound forever. Pray. Thank you.
Respondent.
Is the counsel audible?
Yes.
Much obliged. The counsel solicits permission from the bench to plead.
Permitted.
Much obliged. The council recognizes the gracious presence of your ladyship. However, for the convenience of the proceedings, the council seeks permission to address the bench as your lordship.
Permission granted.
Much obliged, your lordships. Warm greetings. May it please this honorable court. This is counsel appearing on behalf of the respondent in the action. This is Speaker 1. The counsel appearing on behalf of the respondent in the instant case Chote Lal Kumar versus the state, along with my learned co-counsel Speaker 2. Would your lordship appreciate a brief summary of the facts in hand?
You can proceed to the argument. Directly.
Okay. Much obliged, Your Lordship. If the In the instant case, Your Lordship, the respondent will be handling four distinct issues of law to substantiate our case. The counsel will be dealing the first and the fourth issue, and my co-counsel will be dealing with the second and third issue. The first issue that I'll be addressing today is whether the special leave petition filed by Mr. Chote Lal Kumar is maintainable. It is humbly submitted before this honorable court that the current special leave petition is not maintainable because special leave petition cannot be granted when substantial justice has been done and there is no exceptional circumstances that would allow the case to be maintained. The appellant has to be proved that this is a special circumstances. Going in details, Your Lordship, firstly, the special leave petition should be dismissed as this is not an exceptional case. In Preetam Singh versus the state, the Supreme Court held that Article 136 is to be exercised sparingly and in exceptional cases only. And as far as possible, a more or less uniform standard should be adopted in granting special leave in the wide range of matters which can come up before it under this article. The court further stated, Your Lordship, the only uniform standard which, in our opinion, can lay down in the circumstances is that the court should grant special leave to appeal only in those cases where special circumstances are shown to exist. This was again reiterated in Hemraj versus State of Ajmer, AIR 1954 SC 462, which stated that even when the appeal is admitted, the appellant has to prove that the special circumstances exist and there has been grave injustice. Only then the overriding powers under Article 136 would be exercised by the court. In the Council of Scientific and Industrial Research versus KGS Bhatt and State of Himachal Pradesh versus Kailash Chand Mahajan, the court again observed that the special leave will not be granted when there is no failure of justice or when substantial justice is done, though the decision might suffer from some legal errors. The respondent respectfully contends, Your Lordship, that in order to justify a review of the decision under appeal on the basis of the case's merit, the petitioner must establish that exceptional circumstances exist and the failing to intervene would cause a serious injustice. Therefore, the court will dismiss the special leave petition if it comes to the notice that the case is not exceptional. The present case is similar to any other case. There are no existence of any exceptional or special circumstances and no substantial question of law that will make the Supreme Court to grant the appeal. Similar views were upheld in the case of Mathai and Joby versus George and another, N. Suryakala versus Mohan Das and others, Tirupati Balaji Developers Private Limited versus State of Bihar. The court in these cases held that the apex court is not a normal court of appeal. The Article 136 constitutes an extraordinary jurisdiction and vests vast discretionary power to interfere in exceptional cases only. The present case, as mentioned before, is similar to any other case. There are no existence of any exceptional or special circumstances and no substantial question of law that will make the Supreme Court to grant the appeal. Secondly, Your Lordship, the scope of special leave petition. As mentioned in Jamshed Harmuzji Wadia versus Board of Trustees, Port of Mumbai, the court held the power is permitted to be invoked not in a routine fashion, but in very exceptional circumstances. And it's when a question of law of general public importance arises or a decision shout to be impunged before the Supreme Court shocks the conscience. The Supreme Court would not, under Article 136, constitute itself into a tribunal or just court settling disputes and reduce itself into a mere court of error. The power under Article 136 is an extraordinary power to be exercised in rare and exceptional cases and on well-known principles. It has become a tendency of filing special leave petition against all types of orders given by the High Court without taking note of the scope of Article 136. This article was never meant for the Supreme Court to be an ordinary court of appeal. Under the constitutional scheme, ordinarily, the last court in the country in ordinary cases was meant to be the High Court. The Supreme Court, as the apex court in the country, was meant to deal with important issues like constitutional questions, questions of law of general public importance, or when grave injustice has been done, as has been clearly held in Mathai alias Joby versus George and another. In the present case, Your Lordship, there is neither any question of law nor any grave injustice has been done to the appellant. It is so an ordinary case, and thus the special leave petition is not maintainable. All the material evidences were taken into consideration, and the order was passed by the Honorable Court without any biasness or unfair application of law. The judgment of the High Court stands valid, and therefore the petition must be dismissed. In another case, Tahir Khatun by LRS versus Salam bin Mohammed, the Supreme Court held, we are not bound to go into merits, and even if we do so and declare the law or point out the error, still we may not interfere if the justice of the case on facts does not require interference, or if we feel that the relief could be molded in different fashion. It is humbly submitted before this honorable court that there is no requirement to entertain the matter because there is no reason of intervention required in the present case. However, if the court wishes to accept the petition, then it is requested not to hear the matter on its merit. Thirdly, grounds on which special leave petition is granted are not satisfied in the present case. There are some grounds on the basis of which the special leave petition is not granted. Firstly, when the tribunal fails to exercise its patent jurisdiction. Secondly, when there is an apparent error on the face of the decision. Thirdly, when the tribunal has erroneously applied well accepted principles of jurisprudence. Fourthly, the tribunal acts against the principles of natural justice or has approached the question in manner likely to cause injustice. In the present case, Your Lordship, the learned trial court and the Honorable High Court were within the jurisdiction to try this case and give the verdict for the same. There is no erroneous judgment passed by them, as they have taken note of the whole situation that occurred and examined the material evidences. The courts have exercised their power keeping in mind the principles of natural justice and have ensured that no grave injustice has been done. Hence, it is humbly submitted before this honorable court that no valid grounds
Counsel,
can be.
counsel,
Yes, Your Lordship.
referring to the judgments of the trial court and Supreme Court, the basis for their judgments they have based on the diary of the deceased, correct?
Yes, Your Lordship.
Now, the diaries which were written by the deceased are not dated, and
Yes, Your
therefore it
Lordship.
is very, very difficult to determine whether those were written right before she committed suicide or not. Don't you think there is a possibility of grave injustice being done?
Uh, Your Lordship, as my co-counsel will further mention in her submissions the same, I would still like to go on with the question. Uh, the diary that she mentioned was a daily journal. It is not necessary that just before she died there has to be a suicide note or there has to be something written in the diary soon before she died, because there are plethora of cases that my co-counsel will mention later on uh, on how the statements made before 1 month or statements made before 2 months has also been considered as dying declaration by the Supreme Court. Whereas the diary talked about the dowry demands, it talked about the emotions of the deceased, and so the diary can still qualify as a dying declaration. It does not necessarily have to be written at the last moment or a moment soon before she took her life away. If
Please
your lordship is
conclude, Raghav.
satisfied, I'd like to. Okay, yeah.
Counsel, I have a question. What are the
Yes,
principles
your
of
lordship.
natural justice?
There are two cardinal principles of natural justice. One where the judge is the relative of the accused, which is not applicable in this case. Secondly, another cardinal principle of natural justice is um, right to be heard. Now, the aspects for the same is opportunity to be heard. Now, the accused has been given an opportunity to be heard not only once, but twice, which is in the trial court and in the Honorable High Court.
But
Secondly,
again, here,
another,
what will you say about when the court did not go into the plea of alibi? Will that violate the principles of natural justice? Can it
that
be
won't
said
violate
that
the principle.
uh, the accused was not given an opportunity of being heard?
No, that won't violate the principle of natural justice, Your Lordship, because to get into the plea of alibi, we have to try to establish a murder. Here, we were not trying to establish murder. We were trying to establish dowry death and how cruelty led to dowry death and how cruelty or harassment on the deceased led for her to take her life away. So we're not trying to establish that murder was one of the reasons why she died. So not going into the plea of alibi does not is not violative of natural justice. And I believe that the learned trial court and the learned high court went on to the similar lines as my contentions here, and thus decided not to get into the plea of alibi, because this was not a case of murder. It was case of dowry death, which was because of suicide.
Okay, proceed on.
Lastly, according to the doctrine of exhaustion of alternative remedies, all statutory solutions must be exhausted before approaching the Supreme Court under its special jurisdiction, unless obviously special circumstances can be demonstrated to persuade the court that the appeal must be allowed. The petitioner had the option of appealing to the High Court's higher bench or filing an application of revision. The respondent humbly submits that in light of the apex court precedents, the petitioner's failure to exhaust the available alternative remedies rendered the current special leave petition unsustainable. Your Lordship, as I'll be arguing the next submission, the Council seeks permission to begin with its arguments.
Permitted.
Much obliged, Your Lordship. The next issue that the Council will be dealing with is whether Section 304B and Section 498A of the Indian Penal Code 1860 is unconstitutional. The state would humbly submit before this honorable court that Section 304B and Section 498A of IPC are in fact constitutional, as it is clearly seen that the increase in number of dowry death and cruelty is a matter of serious concern. Firstly, I'd like to talk
Counsel.
about how.
Counsel, can we hear regarding the constitutionality of provisions? A full bench of Supreme Court, can we hear on the constitutionality of the provisions of the statutes?
Sure, Your Lordship.
Please continue.
Firstly, I'd like to get into why the abuse of legislation does not invalidate 304B and 498A of the IPC. In the case of Sushil Kumar Sharma versus Union of India and others, it was provided that it is well settled that mere possibility of abuse of provision of law does not per se invalidate a legislation. Though there are numerous cases with false allegations of dowry, death, and cruelty under Section 304B and 498A of IPC, it cannot be declared unconstitutional. In another case of A. Thangal Kunju versus Venkat Challam Potti, authorized official and income tax officer, it provided that it is so to be presumed, unless the contrary was shown, that the administration of a particular law would be done not with an evil eye and an unequal band. In the case of Buddhan Chaudhary and others versus State of Bihar, the court referred to the contention of another case, namely Snowden versus Hudgens, wherein the court held the judicial decision must of necessity depend on the facts and circumstances of each particular case. And what may superficially appear to be an unequal application of the law may not necessarily amount to denial of equal protection of law, unless there is shown to be present in it an element of intentional and purposeful discrimination. Further, the discretion of judicial officers is not arbitrary. It is also held, the court repelled, that the contention holding that on the possibility of abuse of a provision by the authority, the legislation may not to be held arbitrary or discriminatory and violative of Article 14 of the Constitution. It must be understood that whenever legislation is passed, it is passed not with an evil intention. The validity to such legislation is given by the judiciary, and if it is unconstitutional, it declares the said law as ultra vires. The constitutional validity of Section 304B and 498A of IPC has been upheld in several judgments, namely Sushil Kumar Sharma versus Union of India and others, Balakrishna versus State of Maharashtra and others, P. Salayas Narayan versus Polavarapura Sundar Valya. In the case of Krishna Lal and others versus Union of India, it was contended by the respondent that it was further highlighted that the evil of the dowry has spread its tentacles by leaps and bounds. And even the spread of education has not helped to liberalize the attitude of society regarding dowry. On the contrary, even in educated society in the urban areas, such incidents have increased considerably. In many cases, higher the education of the boy, greater the demand for dowry. Under these circumstances, the legislature thought it fit to enact special provisions of Section 498A and 304B of the Indian Penal Code for curbing the vice of cruelty towards married women as well as dowry debts. Secondly, Your Lordship, Section 304B and 498A of IPC are not violative of fundamental rights. Article 14 is the fundamental right guaranteed to all the citizens of India. It provides equality before law. This provides that all persons are equal before the law and are entitled to receive equal protection before the law within the territory of India. In the case of Indiraj versus Sunita, Section 498 of IPC was challenged on the grounds that it was violative of Article 14 of the Indian Constitution. However, the court held that wide erections have been given in the court in the matter of interpretations of the words occurring in the laws and also in the matter of awarding punishment. If giving this discretion is thought to be conferring arbitrary powers on the courts, most of the provisions of law will have to be struck down as ultra vires. It is well established principle of law that such discretion cannot be said to be arbitrary and thus does not come into conflict with Article 14 of the Constitution. Especially Article 15, Clause 3 of the Constitution clearly states that the state can make any special provision for women and children. This is created to protect the women from cruelty and that they have been facing for a longer period of time, which is further driving them to commit suicide or become an easy target of violence by husbands and husbands' family and target of murder. Therefore, Section 304B and 498A of IPC stands to be constitutional, valid, and inter-vires. Lastly, Your Lordship, even though Section 498A and 304B are not gender neutral, it cannot be contended that they are gender discriminating. Merely because there's an abuse of the provision does not mean it can be declared invalid. The evil of dowry has spread its tentacles by leaps and bounds, and there is a need for gender specific law to protect women for such evil. Even though these sections are not gender neutral, they will continue to uphold the validity and remain constitutional. This is further protected under Article 15, subclause 3, as discussed previously. If the council is if your lordship is satisfied by the arguments, the council seeks permission to call upon its co-counsel for further submissions.
Permitted.
Warm greetings to your lordship. I, co-counsel Speaker 2, will be arguing the remaining issues. Your lordship, as I will be arguing the remaining submissions, the co-counsel seeks permission to begin with its arguments.
Permitted.
Much obliged, your lordship. The issue that the council will be addressing today is whether the diary written by Kiran Kumari can be considered as a piece of dying declaration. It is humbly submitted before this honorable court that the diary recovered by the police during the investigation must be considered as a dying declaration. Dying declaration has been defined under Section 32 of the Indian Evidence Act. Even though this section does not exclusively highlight the term dying declaration, but the implied intention points towards it. An important ingredient for an evidence to be a dying declaration is that it must relate to the cause of death or the circumstances of the transaction which resulted in the person's death, as these were held in the case of Didi Gram Bhikshapati and another versus state of Andhra Pradesh, Tapinder Singh versus state of Punjab, Okaram versus state of Rajasthan. Your lordship, the expression circumstances of the transaction which resulted in his death means that there must be some nexus between the circumstances and the death of the victim. The instant case satisfies this ingredient as the diary has established sufficient nexus because it narrated the ways husband used to make dowry demands. Your lordship, as per the case of Sharad Birdi Chand Sarda versus state of Maharashtra, the justice had held that when main evidences consist of statements or letters written by the deceased which are in direct connection or related to the death of the deceased and which reveal a telltale story, the said statement would clearly fall within the ambit of Section 32 and therefore admissible, and distance of time alone in such case would not make the statement irrelevant. Your lordship, the Indian law incorporates a statement, the circumstances of this transaction which resulted in his death in cases where the cause of that person's death is called into question. As previously argued, the cause of victim's death is in fact a question, and the circumstances which led to her death has been established by the diary. As per the case of Sudhakar versus State of Maharashtra, Your Lordship, here the court held that as distinguished from the English law, for a statement to be relevant under Section 32 of the Indian Evidence Act, it is not required to be made in expectation of death, and that statement of the victim who is dead is admissible in so far as it relates to the cause of his death. Your Lordship, the language used under Section 31, Clause 1 of the Indian Evidence Act gives rise to the proposition that in the case of Sharad Birdi Chand Sarda versus State of Maharashtra, it was held that distance of time would depend or vary from the circumstances of the case, where death is a logical culmination of continuous drama, long in process, and is a finale of the story. The statement regarding each step directly connected with the end of the drama would be admissible because the entire statement would have to be read as an organic whole and not torn from the context. In the present case, the marriage between the victim and the accused was in doldrums, and she also narrated the ways dowry demands were made through the diary. In addition to it, the father of the victim knew of such dowry demands because he was the one who made the payment of such huge amount to his son-in-law. Due to such continuous cruelty related to dowry demands, the victim was forced to take such an extreme step. Your Lordship, therefore, the diary must be declared as a dying declaration and admissible before the court of law. Your Lordship, here another important ingredient for a statement to be a dying declaration is that it should be truthful and credible. Your Lordship, in the case of Lalubhai Devchand Shah and others versus State of Gujarat, the Supreme Court held that the dying declaration must be scrutinized to the extent of its truthfulness, like any other material pieces of evidence. The diary in the instant case is coherent, consistent, true, and voluntary, therefore satisfying the above ingredient as well. It must be considered as a dying declaration because the diary is credible, because it showed the ways demands were made for dowry. The truthfulness of the diary is also established by the fact that an FIR was filed by the father of the victim because diary was the cause of her death and the mental torture that she suffered. Your Lordship, in the case of Sharda versus State of Rajasthan, the court observed that if the dying declaration is to be completely excluded in a given case, it may even amount to miscarriage of justice, as the victim alone being the eyewitness is a serious crime. The exclusion of the statement would leave the court without a scrap of evidence. Your Lordship, even in the present case, the diary must be considered as a dying declaration. If not, it will lead to serious miscarriage of justice. Even though the diary did not prove in great detail the reason behind her death for the sake of the argument, Your Lordship, the court is not justified in ignoring the smallest of the information provided. Even though the diary did not give sufficient happenings of the events, it cannot be rejected as a dying declaration on this ground. Your Lordship, in the case of Pani Ben versus State of Gujarat, the court reached the following conclusion after reviewing the entire scope of law on the principles governing dying declaration, wherein in the case of State of Maharashtra versus Krishna Murthy Lakshmipati Naidu, the Supreme Court held that the learned judges of the High Court were not justified in ignoring the dying declaration of the deceased merely on the ground that it did not include the statement as to how the accused had received the injuries. Furthermore, in the
Counsel,
yes, Your Lordship.
as you're discussing regarding dying declaration, can you share with us any judgment where dying declaration has been used to convict an accused under Section 304B?
Yes, Your Lordship. Your Lordship, there is a case of Ramesh Kumar versus State of Chhattisgarh. And the court here held that in the case of suicide by a married woman, the notings made by her in a diary about the cause of her death would have the same evidentiary value as a dying declaration. Apart from that, your Lordship, in the case of Alok Haldar versus State of Chhattisgarh, the conviction under Section 304B was set aside by the court after considering the diary of the deceased, where she mentioned that her husband have adulterous relations and she was living life in celibacy. Court believed in the diary of the victim and shifted the grounds for conviction.
Please proceed.
Much obliged, Your Lordship. Your Lordship, further on, In the case of Kosa and another versus state of Orissa, the court held that even an incomplete dying declaration can be held reliable, even if the deceased, having narrated the full story, fails to answer the last formal question as to what more he wanted to say. Your Lordship, therefore, in the instant case as well, even though the diary did not give complete details of the events, it is not justified to be rejected as a dying declaration. In addition to this, the learned trial court and the High Court have considered the diary as a dying declaration. The learned trial court and the Honorable High Court are of such intellect that they have deeply scrutinized and examined all the material witnesses, and only on that basis the diary has been declared as a dying declaration. On satisfaction of the above grounds, it is respectfully submitted before this Honorable Court to consider the diary as a dying declaration. The Council seeks permission to move on to its next submission.
Affirmative.
Much obliged, Your Lordship. The next issue that the Council will be addressing is whether the judgment of learned trial court and Honorable High Court is erroneous. It is submitted before the Honorable Court that the judgment of learned trial court and the High Court is not erroneous. The courts have been successful in establishing the guilt of the accused for causing cruelty and death of the victim by fulfilling necessary essentials. Your Lordship, in the case of Kamesh Panjiar versus State of Bihar and Kashmir Kaur versus State of Punjab, the essentials for Section 304B of IPC were established as the death of the woman should be caused by burns and bodily injury or occurs otherwise than under normal circumstances. Second, the death must have been occurred within 7 years of marriage. Third, subject to cruelty by husband or the relatives of the husband. And lastly, the cruelty must be connected with the demand for dowry. Your Lordship, moving on to the very first essential, the death of the woman should be caused by burns or such bodily injury or occurs otherwise than under normal circumstances. In the present case, Your Lordship, the facts provided that there was death because of strangulation, which is otherwise than under normal circumstances. Therefore, the first essential that the woman has died as a result of unnatural circumstances stands fulfilled. In the present case, this admissibility of the medical opinion that the death of the victim was because of strangulation by the doctor must be accepted and admitted along with the diary, which is treated as a dying declaration by the learned trial court and the Honorable High Court. Moving on to the second essential, that is death must have occurred within 7 years of marriage. Your Lordship, the facts of the case clearly presents that within 2 years of the marriage of the victim, she was subject to cruelty because of dowry demands, which led to her death. The facts provide that they got married on 1st January 2020 and on 15th October 2022, the victim was found hanging. Your Lordship, I would like to highlight the term soon before here, which was pointed out as an important ingredient of Section 304B, as was held in the case of Rajendra Singh versus State of Punjab. This term is a relative term which may differ from case to case, which was held in the case of Surinder Singh versus State of Haryana. Your Lordship, this term is not synonymous to the term of immediately before, which was held in the case of Kansraj versus State of Punjab. Your Lordship, in the present case, there is a close interval between the cruelty and the death of the victim. The cruelty for dowry is shown to persist, thus this essential stands fulfilled. Moving on to the third essential, that the woman must be subject to cruelty by the husband or the relatives of the husband. Your Lordship, this essential stands fulfilled along with Section 498A because the term cruelty means the same in both these sections, which was also held in the case of Kalya Perumal versus State of Tamil Nadu. The accused has fulfilled the requirements of Section 498A as there was a willful conduct in treating the deceased cruelly and coercing her to meet the unlawful demand for dowry. The victim was exposed to mental torture, which falls within the ambit of cruelty, which was held in the case of Baijnath Madhesia versus State of Bihar and Samar Ghosh versus Jaya Ghosh. Moving on to the fourth essential, after the fulfillment of the third essential, the fourth essential states that the cruelty must be connected with the demand for dowry. Your Lordship, the cruelty faced by the victim leading her to commit suicide shares sufficient nexus with the demand for dowry. The husband demanded dowry, which made her life miserable and made her matrimonial life unstable. In the case of Sher Singh versus State of Haryana, it was held that the initial presumption of innocence is replaced by an assumption of guilt of the accused, thus transferring the heavy burden of proof upon him. Your Lordship, the Indian Evidence Act highlights Section 113B, where when the question is whether a person has committed the dowry death of a woman and subject her to cruelty, it is presumed that such person has caused her death, which was again highlighted in the case of Hemchand versus State of Haryana. In the instant case,
Counsel,
yes, Your Lordship.
counsel can in all the cases demand for dowry can be categorized as equivalent to cruelty?
Your Lordship, the Section 304B defines dowry death. And in that definition, there is a use of word cruelty, which is similar to the use of the word,
Correct. But according to the facts of the case,
yes, Your
there are
Lordship.
no facts which would point out towards cruelty being done
Your
by the
Lordship,
husband
yes.
against the wife.
Your Lordship, here we can infer that a cruelty has been done because it has been backed up by certain cases. Like there is one case of Sobha Rani versus Madhukar Reddy, in which the court held that the demand for dowry amounts to cruelty. And therefore, based on this case law, we can infer that even though there is no mention of cruelty, it can be informed that cruelty was there because the life of the victim was miserable. Her matrimonial life was in doldrums, and there was a continuous demand for dowry.
Right, but being in doldrums does not mean miserable, does it?
Your Lordship, if there is a continuous demand, Your Lordship, if there is a continuous demand for dowry and keeping the victim first at her parental home, then bringing her back to the marital home, again to the parental home, and then again bringing back to her to the matrimonial home, there is an instability in the married life, which is not a normal circumstance. And based
Right,
on
but those not normal circumstance, does it become cruelty?
Your Lordship, we can say that it does become cruelty. It may not be a physical cruelty, but it can amount to mental cruelty.
Please continue with the argument.
Much obliged,
So
Your Lordship.
counsel,
Yes, Your
when
Lordship.
you said about this cruelty, what about the fact that when you look at the statement of fact, so basically the victim, just give me yeah, she went back to her father's place by her will, right? And then after that, this Mr. Chotelal, he came and brought her back to her matrimonial home, and then also promised to keep her happy. So how would this act or this gesture would it still amount to cruelty?
Your Lordship, this will
Well,
still amount.
I'll just add one more thing. In
Yes,
that
Your Lordship.
first incident and only one instant, only it stated that Chotlal Kumar asked the dowry. In
Yes, Your
that
Lordship.
itself, he change of his heart, he bring back her wife to the home. After all the instance, Kiran Kumar is stating that her husband asking dowry.
Yes, Your
So there
Lordship.
is some gap between that.
Your Lordship, the facts clearly do say that the accused promised to keep her happy, brought her back to her matrimonial home, and apologized to her. But here, Lordship, the accused again demanded dowry of 60 lakh rupees, which clearly shows that.
Kiran Kumar is stating Chotlal Kumar is asking. So I think the court is inferred that when first time he asked no demanding dowry, that diary was written on that time itself.
Your Lordship, the diary, if
Because
the
there is no date mentioned, there is no date mentioned there.
yes, Your
So how
Lordship.
can you prove that it is continuous process? Because that 2 years, you can see the fact sheet. There's 2 years. There is no demand of dowry from the Chotlal Kumar.
Your Lordship, though for 2 years there is no demand for dowry, but right after the 20 days of a matrimonial home, and when she returned to her parents' home and told them that her husband was demanding dowry, that is a luxurious car. So her father gave her again 10 lakh rupees and sent back. But again, Chote Lal Kumar demanded dowry, and since that period, she has been keeping the diary as a journal in which she narrated the ways dowry demands were made. And later on, Your Lordship, that is on 10th September
There is
2020.
no evidence on record to say that it was a daily diary or the
Yes,
diary was dated.
yes, Your Lordship. Your Lordship, but it did highlight the fact that dowry demands were being made. And the
Correct.
dowry
Those
demands
dowry
were,
demands could be 2 years back. That's what my co-judge is just pointing out.
yes, Your Lordship.
Your
Now,
Lordship, sorry for interruption, but if it is allowed, I would like to highlight one of the facts of the case mentioned here.
please go ahead.
Yes. The third paragraph states that on 10th September 2022, Kiran Kumari went to her father and told him that Chote Lal Kumar is asking for rupees 60 lakhs. 10 September 2022 and her death on 15th October 2022 is a gap of 1 month. This is what I wanted to mention. Secondly, I also want to highlight that Chote Lal Kumar on 5th August 2020 stated that Chote Lal Kumar took his wife and left her in her parents' house and told them that she could get back to her matrimonial home only upon the payment of rupees 50 lakhs. The facts were ignored, so I wanted to put it up right here. That is all that I had to say, Your Lordship. Thank you so much.
But counsel, you missed the line when you read that that Chote Kumar took his wife and left her in her parents' house. After that, it also says that after a few days, Chotelal Kumar had a change of heart and he brought back the wife to his home and also apologized her and promised to keep her happy.
Your Lord,
I agree. I agree, Your Lordship. It happened. But marriage as an institution in India, uh, it's a very pious institution, and the fact that a marriage would become unstable, and the fact that there were continuous demands of dowry of 30 lakhs, 50 lakhs, and 60 lakhs puts a lot of mental pressure on not only the victim but also the family of the victim. And the mere fact that her marriage could actually become her marriage could actually end also puts a lot of mental pressure again on the heads of the victim, as has been seen in a lot of other cases, because marriage is a very pious institution, and in Indian society, in Indian society specifically, marriage is considered to be very important. So I think that was enough to establish that only apologizing and then bringing her back home again and then again asking for dowry does not does not really help the case here, or does not really help the accused here. Thank you, Your Lordship.
Okay, continue.
the council seeks to proceed further. Much obliged, Your
Uh,
Lordship. Your Lordship, therefore, in the instant case, the husband is in question of causing cruelty, that is a mental cruelty, and therefore, in accordance with the law, he is presumed to be guilty of causing a death. So therefore, it is humbly submitted before the Honorable Court that all the essentials of both these sections are fulfilled, and the learned trial court and Honorable High Court have not erred in their judgment. The council seeks permission to move on to its prayer.
Permitted.
Much obliged. Whereof it is prayed, in light of the issues raised, the arguments advanced, and authorities cited, that this Honorable Supreme Court may be pleased to adjudge and hold that the special leave petition is not maintainable. The diary written by Kiran Kumari can be considered as a piece of dying declaration. The learned trial court and Honorable High Court have not passed an erroneous judgment, and the section 304B and 498A of IPC 1860 are constitutional, and pass any other order, direction, or relief that it may deem fit in the best interest of justice, fairness, equity, and good governance. And for this act of kindness, the respondent shall duty bound humbly pray.
Rebuttal is there?
No, Your Honor.
Okay. Courtmaster.
Yes. So we move further now. Since we have reached to the end of the session, I requested both the teams to exit now. So this is we will continue with your discussion.
Thank you. Good evening, sir. Good evening.